176.
Okay. Ms. Thomas, you were about to call your next witness, Ms. Kristen Smith. Is that still where you'd like to go?
Yes, Your Honor, thank you.
Ms. Smith, come on up to our witness stand.
You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, it is.
Hey, Ms. Smith. All right. Briefly, because we've already had so much testimony, I just need to make sure you authored the court report that's before the court today, correct?
Yes.
And there are several attachments, and then you also provided separately from that packet an additional document related to the middle child and her therapy notes, correct?
Correct.
And are there any updates or modifications that you're aware of that need to be made to your report or to the documents that you've submitted with it?
No.
Okay. As it relates to some of the testimony you've heard today, I just want to clarify a few points. Have you received any updated income verification from Mr. Davis during this last review period?
I don't believe during this reporting period. I've received one since the case has started. And that's the letter that Mr. Davis is referring to that his employer sent me.
Okay.
That was by text.
And then as it relates to parenting time, can you confirm the last time that Mr. Davis exercised parenting time?
I believe it was on June 3rd.
And would that have been with Megan Spears through Orchards?
Yes.
It was July.
Okay, Mr. Davis, the time frame for your testimony has concluded. Please don't interrupt.
Thank you, Your Honor. All right. And let's see. As it relates to his testimony that the children got lice from, I don't know if it's clear whether it was the department or Catholic Charities. Was that ever addressed in this matter?
It was very early on. It was shortly after the removal, and they actually got head lice from the daycare. And then they came to the office and actually brought the lice to our office. And during that visit, I had asked Ms. Davis to put hats on the children, which she did.
Okay. And that would have been back in November?
Correct.
And generally speaking, both Mr. Anderson and Ms. Davis are fully compliant and or have satisfied all elements of their case service plan?
Yes.
And as for Mr. Davis, he has been very compliant with his case service plan, other than communicating with you, keeping you informed on some of those basics that are part of a standard case service plan. And then obviously lately the parenting time, but as other services, parenting education, the anger management, domestic violence classes, compliance with probation, the drug screens, all of that has been okay enough, correct?
Correct.
Okay. Some of I guess one of the main things that we've heard from Mr. Davis is his inability to work with you. And do you have any issues with Mr. Davis that you can't work with him?
No, I work with essentially all of my clients are difficult. Either they like me or they don't, but based on their progress, their engagement, their benefit, that's where my recommendations, come from. Mr. Davis has a difficult time engaging with anybody. FTMs, TDMs that are actually facilitated by a third party, he has been terminated from because he's been disrespectful, rude. Any essentially person of authority, Mr. Davis has a very difficult time engaging with.
You've included some screenshots of text messages between the two of you, and then also a thread of emails. Are there any updates to those communications?
No.
And so you made a
So-
valiant effort to continue to ensure that Mr. Davis could exercise parenting time. You made a valiant effort to engage with his attorney as he asked you to do so. And there's even an email from me in which I have never received an email response from either Mr. Rains or Mr. Davis. Have you?
No, I have not.
And at this time, do you believe that Mr. Davis has demonstrated benefit from any of the services that he is engaged in, despite having good recommendations from the service providers?
No, I don't.
And can you briefly elaborate why you have that opinion?
Throughout, since start to finish, Mr. Davis has not, he still doesn't take any accountability for his actions. He doesn't feel that he's traumatized his children. He said today essentially that, because he took a plea deal, essentially this should all go away because it didn't happen. That's not the case. If Mr. Davis can he works in Carlton, lives in Carlton, but works in Tecumseh. He has no problem getting there for work. I don't understand the difference of driving to Adrian to see your kids. Mr. Davis has not engaged with me or anybody else from the agency to try and, reduce these barriers that he seems to have. But I don't think that Mr. Davis thinks that he has any issues. And I don't know how to service that.
Is there a reason that parenting time at this point in time is being recommended to be supervised at either the department or Catholic Charities?
So it was essentially, when the case started, recommended that his parenting time be only at DHS, given the reason for the case, his violence. They wanted security to be there. And then we moved it to our agency and made sure that we had additional staff in the office. And then when Ms. Spears took over and she was transporting the children for visits and helping out with that, then she was comfortable with it in the public place in the park. And those visits went well. And several weeks before that program ended, I had made attempts to get with Mr. Davis about setting up visits, knowing that that program was going to be ending. And still he refuses to. I offered that we could do visits at, a park in Adrian. I offered outdoors now that it was summer. We have several parents who bring strollers or wagons. We do chalk outside. We do scooters. I offered all of that. And essentially he just told me that I need to contact his attorney. So that's where we're at.
Okay. And do you believe, I'm going to actually strike that question. I mean, frankly, I don't have many questions of you because the parents have essentially agreed that everything in the report is accurate. I guess the only point is that Mr. Davis has indicated Ms. Spears provided information in which she would not recommend supervised parenting time. Do you have that with you, or were you ever provided that?
I do not have that. Mr. Davis has sent me probably 50 to 100 screenshots of text messages that I have weaned through. Most of them is just arguments between him and Ms. Davis. So if it was in there, then it was missed. But no, I don't have anything from Ms. Spears stating that his visits should be unsupervised.
And that's not in her report to the best of your knowledge, is it?
I don't believe so. I'm also not sure, just in working with orchards, I'm not sure if they are even able to make a recommendation to the court of whether visits are supervised or unsupervised. I think that they just report on how the visits go in general.
And at any point in time during your work on this case, have you ever indicated to any of the parents involved that the court orders were simply voluntary?
No.
Thank you. Your Honor, I have no further questions of Ms. Smith. I would ask the court to accept the court packet. There might have been two submissions. A pretty lengthy one of like 62 pages and then another cover sheet with a therapy report for the middle child.
Objections?
No objections.
No.
No objection.
Thank you. They are received, including the additional report that came in August 18th. Questions for this witness, Mr. Raines?
Yes, ma'am, you were asking questions about your communication with Megan Spears. Have you in fact inquired of her as to whether she has recommended that there be unsupervised visits between Mr. Davis and his children?
No, I have not specifically asked for that.
Why?
I haven't been in contact with Ms. Spears since her reports. She sends me an email with the report. And that's the extent of it.
You would agree that there's nothing in the case report that she authored that would indicate that supervision is indicated. Wouldn't you agree?
No, can you repeat that? I guess
Sure,
I don't understand.
you would agree that there was nothing in the report that she authored that you've attached as part of the report for today. She didn't indicate anything that would indicate that supervision is required, did she?
No.
In fact, she has indicated that Mr. Davis had displayed bond and attachment with both of his children, showing them physical and emotional affection throughout each of their visits, correct?
Correct.
And this was progress that was made by Mr. Davis over the course of all of the visitations that he exercised, correct?
Yeah, I don't think that Mr. Davis ever was not necessarily bonded, or, I mean, the very first visit that I watched, the kids were excited to see him. That wasn't the issue. It's Mr. Davis's behavior that is the issue.
But it's not his behavior with his children, though, correct?
Not always, but yeah, we've had to end meetings because of his behavior when the children have been present. He's told the middle child that he wasn't her dad anymore.
Well, that wasn't within this last reporting period, was it?
No, that was the last reporting period.
Okay, over this last reporting period, according to what Ms. Spears has observed, everything seems to have been appropriate. Would you agree?
Yes.
And those visits that were occurring with some progress have occurred in a community context, not at DHS or at the Catholic Charities Building, correct?
Correct.
And it was Mr. Davis who had requested of you, probably repeatedly, that he be able to have those in the community, including at a park in Tecumseh, correct?
Yes.
That would have been continuing what the status quo had been for his visits with his children, correct?
Correct. And I asked Mr. Davis, per his request, if he would like to expand his visits to twice a week. Those text messages, I believe, were also submitted, and he declined.
Well, you declined the opportunity to have the children in Tecumseh, correct?
Correct.
You have only insisted upon those being exercised at DHHS, right?
Or in Adrian. I offered parenting time of parks in Adrian.
Okay. Is this a matter from the sake of DHHS of convenience, that simply there's not transportation that's available to take the children to an area where they had been exercising their parenting time with their father?
No, our agency services Lenawee, Hillsdale, Monroe. We visit in Detroit.
Okay, so DHHS has, has been able to transport the children to Mr. Davis's preferred area where he had been exercising parenting time.
Ms. Spears has, the supportive visitation coach for the 16 weeks, offered that service. And then when I tried to contact Mr. Davis to set up a plan, he refused to engage with me and asked me that I contact you.
All right, but ma'am, just all I'm asking is DHHS capable of having the children continue with the community visits that would be in Tecumseh?
Yes,
And that's what Mr. Davis requested of you, correct?
yes, and I asked, essentially, there's no, we're not gonna accommodate him when he can't provide me with his income, his schedule, anything. And he
Okay, so
refuses to engage with me or
all right.
provide anything to the agency, so
So ma'am, you were willing to have the children transported at his request to Tecumseh so that those children could visit their father, but you didn't get income information from him? And that's what held it up? That's what stopped you?
no, it's his lack of involvement and engagement. He won't communicate with me, as I have continued to provide documentation of for the last 9 months.
Well, your interest is in facilitating a relationship between these young children and their father, correct?
Correct.
And those children have been excited about seeing their father, and the reports are that those visits have been positive, at least within this last reporting period, correct?
As far as Mrs. Spears has reported, yes.
Well, you haven't observed them with interacting with their father, have you?
No, because Mr. Davis hasn't engaged in parenting time.
Well, Mr. Davis has requested of you that parenting time occur in Tecumseh to continue that. You've had the ability to
Your Honor,
do.
I'm going to object to this line of questioning. If Mr. Raines wanted to counsel his client, he should have done so when I emailed him earlier this month and encouraged him to tell his client to comply with a court-ordered case service plan, in which that means that his client is to communicate with Ms. Smith. So I'm going to object to this line of questioning as to relevant. We have established that there's a line of communication that all Mr. Davis is continuously saying is talk to the lawyer. Ms. Smith attempted to do that.
Okay, any comments about the relevance in response there, Mr. Raines?
Yes, my client has clearly, according to the witness, expressed an interest in seeing his children and has communicated with her according to what the witness has indicated. And she has indicated that she would not present the children to Tecumseh. She's insisted upon, I believe it's Ormsby, and Adrian instead. So I'm asking her about what is really the impediment for him to be able to exercise his parenting time. And I believe I understand, at least in part, what that is. And that's the failure to present income information, apparently. I think this is all relevant to his communication, the communication of the witness with my client.
Does anyone else wish to make a comment on the objection?
Your Honor, I would say that Mr. Raines has mischaracterized the testimony of the witness and has become argumentative. So I think the objection should be granted on that basis.
Any comments, Mr. Brooks?
None that I think anybody would appreciate. No.
Ms. Underwood?
I believe it's accurate that Ms. Smith reached out to Mr. Raines per the request by Mr. Davis to further discuss parenting time. That attempt was not answered. And so again, I think it's been asked and answered and also reflected in the court report.
Yeah, I agree with Mr. Fry. He phrased it how I was going to respond, which is that these testimony speaks for itself. This line of questioning is argumentative at this point, and in fact, cumulative. The information has been presented, and I would ask you to move on to your next question, Mr. Raines.
Thank you. With respect to the income information, you do know who the employer has been for Mr. Davis, correct?
I believe it's the same employer, yes.
Have you requested any income update from the employer?
No, it's Mr. Davis's responsibility to provide me with monthly income verification per his case service plan.
What was the daycare facility that was investigated and it was determined that lice was at that facility?
I'm not sure it was necessarily investigated. The children started attending the daycare upon their removal, and it was noted that I believe one of the children there had lice, and then the two youngest in this case also got it.
Okay, just what was that facility or that daycare location?
It's a daycare in Adrian, or in Tecumseh. I can't think of the name of it right now.
Did you direct that the children not be able to have any video contact with their father?
Not necessarily. His parenting time is supervised per the court order and at the discretion of the children's therapist. And any additional parenting time, essentially by FaceTime or Zoom, is just that extra. If the children, that's a perk of the kids being cared for by a relative, is that they do have that opportunity if they don't abuse it. If the children were placed in a unrelated licensed foster home, that wouldn't be available to them. Mr. Davis abused that several times by calling the grandmother a fucking cunt.
You think that happened on more than one occasion?
Yes.
It sounds like you're not necessarily disputing what Mr. Davis has indicated to you, that Ms. Spears, there's text messages from Ms. Spears to him that supervised parenting time is unnecessary, because you just haven't looked for it or haven't found those messages?
Correct. I'm not disputing it. I just have not seen them. He informed me that he was going to be submitting, he doesn't trust me, so he said he was going to submit everything to his attorney, so.
All right, ma'am, those are all the questions I have for you. Thank you.
Thank you.
Mr. Fry, any questions?
How you doing today, Ms. Davis?
Ms. Smith.
Ms. Smith, sorry. It's been
Good.
a long hearing.
I feel that.
So, sorry about that, Ms. Smith. Has Brianna Davis successfully completed her case service plan, in your opinion?
Yes, I believe so.
She's done everything that you've asked of her?
Yes, she has.
Okay. Now, as far as Mr. Davis, when is the last time that he exercised any parenting time?
I believe it was June
Objections are
3rd.
asked and answered.
Oh, Mr. Raines, you know that attorneys get to ask the same questions, even if they didn't ask them the first time?
Okay.
Overruled.
So, this reporting period started May 29th, I believe, right?
Yes,
So he exercised, what, one visit of parenting time during this whole reporting period?
sounds accurate.
Okay. Now, how is the process for the parenting time? Are the kids brought somewhere? Does he have to give notice on the day of or ahead of time?
He needs to confirm 2 hours prior to the visit.
So the kids don't know whether they're gonna see their dad, until 2 hours before the visit starts?
Yes, yes.
Is that traumatic for the kids every week? Potentially wondering if they're gonna see their dad and then him never showing up?
I'm going to object. It's speculative at this point. I don't know if the witness has qualifications to offer, whether it's traumatizing for these particular children or any for that matter.
Well, did you want to lay some foundation on whether or not you can answer that, Mr.
I can just rephrase a
Okay.
little bit here. So, do you have any interaction with the children?
Yes, I do.
Okay. And do you have any insight on, how it affect them when their father continually doesn't show up for the visits with them?
I'm going to object and for more foundation. The fact that she's had contact with them, I don't know if that's one telephone call with them 3 months ago. I don't know what that means.
The question was just how she has observed it affecting the children. There's no foundation needed to answer that question.
Absolutely.
Would anyone else like to weigh in on this objection?
I wish everybody'd shut up and just move on with what matters, which is a long way from where we've been, which is why I held my voice earlier on that objection where I thought the exact same thing.
Okay,
We're just arguing for the fun of it.
Ms. Thomas, did you have an opinion on the objection?
I guess to me, the rules of evidence don't apply. It sounds like it's more of a weight of the evidence situation here. And I believe the court has a discretion and can make that determination in its findings.
Ms. Underwood?
I have no position.
Thank you. The witness can speak to her personal observations, so the objection is overruled. Did you need to have the question repeated?
Yeah, repeat the question.
So, have you observed, any effect, the father, not continuing to not appear for his parenting time, having any effects on the children in this case?
I haven't, because of their ages, and also their awareness of dates and times and when they, should be seeing him. That's not something that I directly ask them. I will say that during my monthly home visits, when I ask, how things are going at home and in school and with mom, they don't bring up dad. I think that in therapy, the middle child, might ask more about it, but for me, it appears to be out of sight, out of mind. They don't know Thursdays come and go. I don't think that they've had that consistency to miss it.
Okay, thank you. I have nothing further.
Questions, Mr. Brooks?
One, I promise. Now, do you have any objection to the court releasing jurisdiction over the Anderson child?
No.
Thank you.
Ms. Underwood, any questions?
No, Your Honor.
Redirect, Ms. Thomas?
No, Your Honor.
Mr. Raines, did you have any recross or any other questions?
Nothing further, Your Honor. Thank you.
Thank you for your testimony. You may return to your seat. Any other witnesses today, Ms. Thomas?
No, Your Honor.
All right, witness testimony today, Mr. Raines?
None, Your Honor.
Mr. Fry?
No, Your Honor.
Mr. Brooks?
No.
Ms. Underwood?
No, Your Honor. Thank you.
Very well. Comments in closing, beginning with Ms. Thomas, please.
Your Honor, I'm going to keep this very short. I think that the record at this time speaks for itself. We are asking again to just release the oldest child with Mr. Anderson from the court jurisdiction. And if the court's not inclined to do so, I do appreciate the offer earlier of a mediation. I also think that the parents are on the same page. It's just a matter of getting a stipulated or consent order into the custody file. And if we keep it open, I know that we can do a 7-day notice as well. So I'll just leave that to the court's discretion. As it relates to mom, we are asking that the agency have the discretion for reunification with FRP services in place. And that will trigger the mandatory requirement that the agency reach out to FRP within 30 days of the order to get that in place for mom and the 2 youngest children. As relates to parenting time with Mr. Davis, I think that this court is really well aware of the facts and circumstances that brought us here today. I mean, it had the children removed. And based on his testimony, it's very clear that he is not benefiting from any of the services. It sounds like he really just is checking off a little box saying that he did things. And I really think that it's more at the threat of criminal prosecution rather than actually wanting to benefit for his children. We continue to see that in all of the assessments and reports that we've had as it relates to the children. There's really no denying that these children have this trauma. I was looking back at the original stamped petition that was filed and the disclosures that the children have made. Mr. Davis had pled no contest, and so this court can accept those allegations as true. We have now the psychological evaluation, while not as thorough as we're used to, also indicating that he is prone to some of these personality characteristics that would make him feel targeted. And I think we're seeing that. I think that we are also seeing anyone working with the department, the court kind of collectively being called into his brain as being the problem rather than himself, and taking accountability for his own actions and what caused his children to come into care. We are at reasonable efforts, and frankly, all the case law supports that reasonable efforts is letting the parents know where they can find services and sending them on their way. Fortunately for us, we have a very strong county and a very strong community here, and we have strong expectations from this court, and our workers on a very regular basis offer parents active efforts, and I believe that we are here. I don't think that it's unreasonable to want parenting time, the supervisors of parenting time, to want that to be close to their home base, especially considering the conduct and capacity of this individual who has a history of violence and is dangerous. That's very well supported in all the documents that we've had, and he has done nothing to demonstrate a willingness to engage appropriately with Ms. Smith or someone else from the department. And so I really just think that if you're going to continue to offer supervised parenting time to this parent, we would ask the court that it remain supervised. I guess note to the parent that your orders are not voluntary, they are court orders. So thank you with that. And with that, we're just asking for, I guess, a 90-day review unless a custody order is cut from circuit court before then. Thank you.
Comments, Mr. Raines?
Judge, just with respect to Mr. Davis, I am not sure what the basis is for the updated case report under provision C about likely harm if the children were returned to Zachary Davis. It mentions possible exposure to significant domestic violence, possible physical, emotional abuse, and exposure to parental alcohol use. My client hasn't used alcohol in over a year. There's been an alcohol tether that he's been strapped to. You've heard that there's been no violation of bond conditions during the entire period of time that he was using that until he was released from that last Friday, pursuant to an agreement from the prosecuting attorney's office. Your Honor has heard a great deal about the progress that Mr. Davis has made. There has been a dismissal of the felony charges that were against him. He has a reckless discharge of a firearm in which the children were not involved and were not around. There probably have been some stories that have been told about Mr. Davis, and those have been shared with the children, and maybe that is something that could have caused the children some discomfort, but not the behavior that he is engaged in front of the children. That does not appear to be present from any of the reports. For it to be argued that all of the reports suggest that there's a problem, including domestic violence, I would just look at Exhibit N in the discharge summary. His attitude has been excellent. His attendance has been excellent. His participation has been excellent. He's completed 12-step programs, AA attendance. He's gone through co-parenting. He's been honest and open regards to his addictive behaviors that he's had in the past. The report is, I believe that Ms. Smith has even indicated from Ms. Spears is that the parenting time that he's had with his children has gone well. The only thing that has been he's been criticized for is a comment that he has made where he has used foul and inappropriate language, not to the children or not around the children. So has he referred to some people who are in authority positions in a negative way? Yes. But how is that negatively impacting upon his parenting? It's not. In fact, we've heard that the community parenting that he was doing in Tecumseh was going very well. Unfortunately, the DHHS has been unwilling to accommodate him. He repeatedly requested in his communication with them that he be able to continue to do it there, and notwithstanding the ability, according to Ms. Smith, to facilitate that type of request, the answer was no. And so Mr. Smith has, as a consequence, not been able to have parenting time. He would indicate it's only been since the beginning of July, not before that. He has a good relationship with his children. The children have been excited to see him in the past. That's been clear in the reports that we have. I think the parenting time clearly should continue for Mr. Smith, and I would like that to occur in Tecumseh where he's better able to do it. It's not as if he refuses to have his parenting time. He's been requesting it, as is clear. He does have a problem with his license. He is making progress across the board, according to a lot of the reports that you have before you, and based on the update that I've shared with you, Judge, about what's happening with his criminal case too, where it appears as if he's looking at a period of probation and he would continue to curb his use of alcohol. There is not a threat of domestic violence. He's completed the program. There may have been when Ms. Davis was with him previously, but there hasn't been any reports, any problems of that over the course of the past year. I think Mr. Davis has made considerable strides, and that is documented through the reports and the evidence that you have before you today. And I think his parenting time should continue. And we ask that it be preferably on an unsupervised basis, and that be within the Tecumseh area, he be allowed to exercise that. But I defer to you, Judge, as to what that would be, as what's best for these children who clearly have a relationship with their father, who's gone through the parenting classes and many of the requirements that have been requested of this court. Thank you, Judge.
Comments, Mr. Fry?
Yes, Your Honor. So my client, Ms. Davis, has completed her case service plan. She's done everything that's been asked for the court. She has a good bond with the children. This past reporting period, she's been doing extended overnights with the children up to 4 days consecutively. We'd asked that the court adopt the recommendation of returning the 2 youngest children into her care. Further, the testimony has established that she has a good relationship with Mr. Anderson, and they co-parent the oldest child well together. So if the court felt inclined to discharge, the oldest child, that seems like it would be appropriate at this time. But she has done what she needs to do to have these youngest children returned to her. As far as Mr. Davis's parenting time with the youngest children, he has only exercised 1 visit this entire reporting period, which has been the last few months. Right now it's apparently weekly, and it's unknown whether he's going to actually exercise it until the day of. So everyone and the children, have to plan around that, only for him to have not exercised it at all during this full time. So, that clearly, has to be hard on the children, and traumatic for the children to have to go through this on a weekly basis. Everyone has their own priorities. Clearly, Mr. Davis's highest priorities are not his children, and that's been shown through his actions. So we would ask that his parenting time either be suspended at this time until he can make some more progress, or at least his visits be changed to every other week, so the children don't have to go through this process every week only to have their dad not show up for them. We've heard from the testimony from Ms. Smith that she has not seen any changes in him despite the services that he's undergone, and has not shown progress. So we think that would be appropriate as far as his parenting time, but the children should be returned to my client, Your Honor. Thank you.
Comments, Mr. Brooks?
I take no position with regard to the Davis children. I represent someone else entirely, and this doesn't directly affect his interests. With respect to the Anderson child, I've heard the evidence today, and I think the court is well advised by me to dismiss, to release your jurisdiction of this child and leave the parents to their own devices.
Thank you. Ms. Underwood?
Your Honor, it's become clear to me, not only during this hearing, but during the majority of these hearings, that Mr. Davis continues to take no responsibility or accountability, and frankly, refuses to even attempt to understand the circumstances that brought these children under the jurisdiction. The fact that he doesn't believe that these children have been traumatized is just mind-boggling to me, for lack of a better word. The children's therapist has previously testified extensively, even providing photographs or photos and pictures that the one child has drawn, showing Mr. Davis with a gun in his hand and pointing it at the child's mother. These are real things that these children have endured. And Mr. Davis fails to understand the potential harm that he has created for not only his children, but his stepson. My job is to determine what's in the best interest of these kids. And frankly, I feel like Mr. Davis is becoming less cooperative, less understanding, and thinks that because he took a plea deal means that, you know, everything's just going to magically disappear, when in reality, it doesn't take away what happened. There's just a criminal resolution to his case. The trauma still happened. The event still happened. The outcomes and the fallout has been very real on these children. You know, if parenting time is going so well with Ms. Spears, then Mr. Davis should have called her as a witness. He has every opportunity to call witnesses in his favor, and he's not done that today. He's choosing not to engage in services. I don't think Miss Smith needs to jump through hoops to get Mr. Davis to see his children. In fact, when she attempted to set up additional visits, he called her irrelevant and said to talk to the lawyer. So, and she further offered twice weekly supervised visits, and he's failed to respond. So not only has she offered visitation moving forward, she offered it twice weekly when he was only get it once per week. And again, attempts were made to contact his attorney and they were not responded to. So again, I don't know what more Miss Davis could have done. I'm sorry, Miss Smith could have done. I also believe that it's important to note that Miss Smith has originally in this case, Miss Smith and Miss Davis had issues, and Miss Smith was hard on Miss Davis, but rightfully so. I think that she was consistent in protecting the children and ensuring that these kids were safe. And Miss Davis started working her case service plan and benefiting from services. Mr. Anderson has done the same. So it's not Miss Smith here. 2 of the 3 parents have made significant progress here, and there's one that's not. And that's unfortunate. I would also ask the court, as we can see on video, Mr. Davis has been repeatedly inappropriate throughout this entire hearing, making comments while he's on mute, speaking to somebody in the background. I would ask that all further hearings he be required to attend in person. This is a court proceeding, and we should behave as such. I would ask that the court, if supervised visits were to occur, or if visits were to continue, I would ask that they be supervised at the start and then allow them to be expanded if Mr. Davis can show that he can be appropriate. But at this time, he has not shown me or anybody else the fact that he can behave in a way that would allow for unsupervised visits. I would ask that the court release jurisdiction of the minor child LA with the understanding that either mediation will occur or a stipulated custody order will be put into place within, I would say, maybe 28 or 30 days, something like that, to ensure that there is a updated custody order and parenting time order in the file. I would also concur with the department that that the children be reunified with their mother, with FRP services being put into place, and ask for a standard review on all parties remaining in the case. Thank you.
Thank you. The court finds all interested parties are given notice for purposes of today's review hearing and permanency planning hearing. Reunification continues to be an appropriate goal for all 3 children. Tyler Anderson has had his son returned to his care and he's doing well there. And the other 2 children, the court is ordering them to be returned to the care of their mother effective today. So I'm glad to see that reunification has occurred with these 2 parents. And that will maintain moving forward. I'm not inclined to release the oldest child from jurisdiction today. I have included language in the order that reflects that the parents are offered the standard mediation rate. And by that, I mean Tyler Anderson and Brianna Davis. It's not a high rate because it's court, right? So we know for a fact that SEDRS will accept that. I think Mr. Shadler has accepted it in the past. I don't know if he's still doing mediations. You're welcome to find a mediator of your own choosing, if you like, that would be willing to accept that rate, but the court will support you in that, at least to that extent, to mediate potential resolution to the custody, parenting time, and child support modifications that take into account these proceedings in the current circumstances of the child. I have noted, just for your reference, in the order that the child is obviously placed with Mr. Anderson, and that is contrary to the 2022 order granting mother sole physical and sole legal custody. So with that guidance, I wish you the best of luck in resolving those outstanding issues. And I would invite Ms. Thomas and the attorneys to submit something moving forward that does document if you have an agreement, and that's put into place so that you may not have to appear for the next hearing. So good luck as you move into the next phase of things for your family to that extent. As it relates to the other two children, Ms. Davis is going to remain under the jurisdiction of the court. I'm glad to see that you've made significant progress on your services. I too was very, I would say, as Ms. Nero put it, hard on Ms. Davis in making sure that she demonstrated that her priority is her children. And I see that she's been able to do that and accomplish that. And so I'm glad to see that she will have the opportunity then to provide as the primary parent for her children moving forward. That being said, I know we do have a hearing coming up Tuesday, September 16th on the pretrial on that divorce case. And I would be inclined to still go ahead and set a trial date on that as well. And so that we can, and if the two of you want to agree to stay on for a minute afterwards, we can look at literally just opening up that pretrial today, if you wish. Or setting some dates if you want to see if you can get a hold of your attorney on that, Ms. Davis, and give you a few minutes to do that so that we can get perhaps even a trial date on the books so that the two of you can also have some resolution on the outstanding custody, parenting time, and child support issues. Because at this point, that will appear, assuming that Ms. Davis continues to do as swimmingly as she has, that will be likely what you'll hear from me at the next review period as well. If those issues have not been resolved, that those need to be resolved. And in this case, I think it's especially important as it relates to the younger two children, given the developments that happened on the record today. So this leads me to speaking to the request of Mr. Davis on parenting time. I will continue to grant him the opportunity for supervised parenting time according to what he's entitled to under the manual, with the exception that that's going to be at the discretion of the both children's therapists. And that's because I just want to revisit this for Mr. Davis for a moment, and I won't take too much of your time. But the petition that was filed, it was a supplemental petition that ended up being the subject of the plea in this case. And that was submitted November 21st, 2024. It indicated a number of really serious things that did happen in front of the children, including Mr. Davis threatening Ms. Davis that he was going to cause harm to her stepfather. And let's see, where was the other one that was really? Yes, while she was loading, this is from paragraph 8H, she reported that while she was loading the children into the car, both back van doors were open, with the mother standing on the driver's side and the father on the passenger side. The father pointed a pistol directly at her through the van and made a statement to the effect that he should just kill her and that would solve all the problems. Brianna, the next paragraph reflects, Brianna stated she thought Zach was going to shoot her, and in fear, she ran to the back of the van out of the line of fire. When Zach did not shoot her, she got in the van and fled with the children. The couple continued to argue over the phone leading up to the gunshot, which is, I would assume, the basis for the plea that was eventually taken, wherein the children were no longer part of that interaction. God, frankly. So there were some very serious issues that happened that day. There was a BAC of 0.12 that Mr. Davis blew. He was on probation at the time. He was taken into custody. There was also a number of hearings that took place where we heard from, well, at least one from Ms. Millenbach, where we heard about the children talking about how they were trying to process the trauma of what they had seen. It had a really real effect on these kids. Obviously that incident was very serious, but it was also demonstrative of a pattern in the home that was extraordinarily harmful to the children and resulted in many diagnoses for the children that they're currently still working on with Ms. Millenbach on a weekly basis. On December 19th, I'm sorry, December 9th, it looks like, Zach Davis took a no contest plea to that petition. And I explained to him at that time that although he did not have to indicate directly that he was taking responsibility for the allegations of the petition, that in fact the court would treat the allegations of the petition as though they were accurate and order services for him and his family to the extent that we could try to essentially rehabilitate him so that he could be a safe person for his family, for himself, and especially for his children. And that was ordered. He was ordered into services. They were certainly to address domestic violence and those dynamics in the house, his alcohol use, many of the things that he's had to address through other courts as a result of his criminal proceedings. But to simply deny today that any of that occurred as a result of the plea agreement that was entered is really quite extraordinary. I appreciate his frankness. It's very clear that he is not willing to take any responsibility for the dynamics that he brought into the situation with his children, that he's not willing to acknowledge their trauma as a result of that, or to work with the service providers that are in place in order to try to help his children overcome the damage that's been done as a result of those dynamics. So for all those reasons, the parenting time will certainly remain supervised. It will be at the discretion of, frankly, Ms. Millenbach. I know she's seeing at least one of the children, but it would be at the discretion of a therapist, given today's disclosures and events. I'm not going to require that he appear in person. If he wants to conduct himself in a way that is disrespectful to the courts, he will continue to be muted or asked to maintain appropriate behavior. But again, I think we're getting a very honest picture here of how Mr. Davis feels about himself and about his children and these proceedings. So to an extent, there is some value to that. I have some time available for our next review and permanency planning hearing on November 17th at 10:30 in the morning. That's only an hour and a half, given that the hope is that the custody issues in both cases could either be completely resolved or would be on their way to being resolved in the future.
11/17,
10:30.
10:30.
I'm available.
Mr. Raines, are you available for an hour and a half on that day?
Yes, I am, Your Honor.
Okay. All right. Mr. Fry will be on vacation, so the odds are low he'll be rejoining us.
I think I'll let Ms. Dumont step back in, Your Honor.
All right, very well. All right, the children will remain then, as the court has previously indicated, the oldest with his father and the youngest two with mom. Under the terms and provisions that I've indicated here, there's clearly still a significant risk of harm associated with Mr. Anderson's parenting time and custody. So I've already spoken to that at length. Those will be the orders moving forward, unless there's